Question 1. Topic: Patent infringement and remedies. During comprehensive review of process that needs improvement, pharmaceutical company discovers that competitor has launched drug with formula nearly identical to one of its patented compositions. The competitor argues that its formulation was developed independently and that any similarities are coincidental. The patent holder initiates lawsuit for infringement. Under patent law, which of the following legal principles is most relevant in determining whether the competitor has infringed the patent? The doctrine of equivalence, or which extends protection beyond literal infringement. B. Fair use doctrine, which allows for limited use of intellectual property without permission. C. First sale doctrine, which restricts patent holders' rights after the first authorized sale. D. Public domain principle, which allows public use of expired patents. Answer A. The doctrine of equivalence, which extends protection beyond literal infringement. Explanation: patent infringement can occur even when an accused product does not literally copy every element of a patent claim but is functionally equivalent. The doctrine of equivalence, established in Graver-Tanken Manufacturing Company v. Lind Air Products Company, 1950, prevents minor variations from circumventing patent protection. Assess whether the accused product performs substantially the same function in substantially the same way to yield substantially the same result. Option A is correct because the doctrine of equivalence is a well-established principle in patent law that prevents infringement through technical modifications that achieve the same result. Option B is incorrect because the fair use doctrine applies to copyright law, not patents. Option C is incorrect because the first sale doctrine limits a patent holder's rights post-sale but does not address infringement. Option D is incorrect because the public domain principle applies only when patent has expired, which is not relevant here. Question 2. Topic: Copyright infringement and fair use doctrine. When implementing new protocols in shared environment, an online education company launches digital library containing scanned copies of entire textbooks. It claims that the initiative is purely educational and falls under fair use. The textbook publishers sue for copyright infringement. Which of the following factors is most likely to weigh against fair use defense in this case? A. The nature of the copyrighted work as factual compilation rather than creative content. B. The purpose of use being educational rather than commercial. C. The effect on the potential market for or value of the copyrighted work. D. The transformative nature of the use modifying the original content significantly. Answer C. The effect on the potential market for or value of the copyrighted work. Explanation: the Fair Use Doctrine 17 U.S.C. SS 107 permits limited use of copyrighted material without permission based on 4 factors: purpose and character of use, commercial versus educational, transformative versus non-transformative, nature of the copyrighted work, factual versus creative, amount and substantiality of the portion used, effect on the market value of the original work. Option C is correct because the 4th factor is often the most decisive in fair use cases. If the use significantly reduces the market for the original work, courts are unlikely to grant fair use. The Supreme Court in Harper and Roe v. Nation Enterprises, 1985, emphasized the market impact as key determinant. Option is incorrect because factual works, e.g., non-fiction, are more likely to qualify for fair use, but textbooks contain creative expression, limiting fair use applicability. Option B is incorrect because an educational purpose does not automatically qualify as fair use, especially if entire works are copied. Option D is incorrect because no transformative elements, such as commentary or parody, exist. Simply scanning and distributing books is not transformative. Question 3. Topic: Trademark dilution and genericide. In case where multiple parties have different objectives, startup begins selling new line of vacuum-insulated bottles using the term Thermocouple as its brand name. Well-known manufacturer of similar products files trademark infringement claim arguing that the term Thermocouple dilutes his famous brand. The startup counters that the term is generic and should not be trademarked. Under trademark law, which of the following outcomes is most likely? A. The startup will prevail because Thermocouple is a descriptive term that cannot be protected as trademark. B. The well-known manufacturer will prevail because it can prove that Thermocouple is famous and dilution applies. C. The startup will prevail if it can show that Thermocouple has acquired secondary meaning. D. The well-known manufacturer will lose because generic terms are not eligible for trademark protection. Answer B. The well-known manufacturer will prevail because it can prove that. Thermocouple is famous and dilution applies. Explanation: trademark dilution protects famous brands from unauthorized uses that weaken their distinctiveness, even without consumer confusion. The Federal Trademark Dilution Act (FTDA) and the Trademark Dilution Revision Act (TDRiV) of 2006 set the legal standard for dilution claims. Option B is correct because if the well-known manufacturer can prove that Thermocup is a famous mark, it can prevent the startup from using a similar term that blurs or tarnishes its brand identity, mostly V Secret Catalog Inc. 2003. Option is incorrect because a descriptive term can be protected if it has acquired secondary meaning association with a single source. However, Thermocup is likely suggestive rather than merely descriptive. Option C is incorrect because the burden of proving secondary meaning falls on the startup, and well-known brands are often granted dilution protection regardless of consumer perception. Option D is incorrect because while generic terms cannot be trademarked, Kellogg Company v. National Biscuit Company, 1938, the Thermocup is likely suggestive, not generic, meaning it can be protected. Question 4. In a situation where formal requirements conflict with practical business needs, companies often struggle to balance compliance with trademark laws and market realities. Consider a multinational corporation that has been using a particular logo for over 20 years in multiple countries without formally registering it as a trademark in certain jurisdictions. A competitor in one of those jurisdictions has now registered a similar logo and is enforcing its trademark rights against the multinational corporation, seeking to prevent its continued use of the long-standing logo in that market. Under international trademark law, particularly the Paris Convention and the Madrid Protocol, what legal strategies might the multinational corporation use to assert its rights over the logo despite the competitor's registration? A. The multinational corporation can argue for priority rights under the Paris Convention if it can prove prior use in commerce. B. The company can file an opposition proceeding under the Madrid Protocol, arguing the competitor's registration was obtained in bad faith. C. The company has no legal recourse since trademark rights are strictly based on registration, and the competitor now holds valid rights. D. The multinational corporation invoked the doctrine of trademark dilution to challenge the competitor's registration, regardless of local trademark laws. Answer B. The company can file an opposition proceeding under the Madrid Protocol, arguing the competitor's registration was obtained in bad faith. Explanation: under the Paris Convention, a company may claim priority if it has filed a trademark application in another member country within 6 months. However, in this scenario, the corporation did not previously register its logo, so priority rights do not apply. Is incorrect. Under the Madrid Protocol, which governs international trademark registrations, the company may file an opposition proceeding if it can demonstrate that the competitor's registration was obtained in bad faith. For example, if the competitor knowingly copied an existing brand's logo to take unfair advantage of its established reputation, B is correct. Trademark rights can be based on use or registration, depending on the country. However, in jurisdictions, first-to-file principles apply, which can create challenges for unregistered trademarks. While some countries recognize common law rights based on prior use, this is not universal rule, meaning that complete loss of rights is not necessarily the case. C is incorrect. Trademark dilution applies to famous marks, but it does not automatically override formal trademark registration rights. If the multinational corporations look widely recognized, it might be able to argue dilution, but this would depend on jurisdictional laws, and it does not serve as universal defense against registered mark. D is incorrect. Question 5. During an emergency response where multiple areas are impacted, the legal rights surrounding copyrighted works can become critical in ensuring the dissemination of information. Imagine a government agency issues an emergency public safety announcement that includes copyrighted news footage obtained without the original copyright holder's permission. The news organization later claims copyright infringement and demands the removal of the footage. Under U.S. copyright law, what is the strongest defense that the government agency could use to justify the unauthorized use of the footage? A. The footage qualifies as fair use because it was used for non-profit governmental purposes. B. The footage falls under the public domain since it was used for an emergency broadcast. C. The government agency has sovereign immunity, meaning it cannot be sued for copyright infringement. D. The footage is automatically available for public use under the First Amendment in situations of national interest. Answer A. The footage qualifies as fair use because it was used for non-profit governmental purposes. Explanation: Under U.S. copyright law, the Fair Use Doctrine 17 U.S.C. SS 107 allows limited use of copyrighted material without permission for purposes such as news reporting, education, and public interest matters. Courts assess fair use based on 4 factors. Purpose and character of use. If the government agency used the footage for public safety rather than commercial gain, this favors fair use. Nature of the copyrighted work. If the footage is factual rather than highly creative, this supports use. Amount and substantiality. If only brief clip was used, this strengthens the fair use defense. Effect on the market. If the use does not harm the copyright holder's revenue potential, this favors fair use, because the emergency nature of the situation makes the use non-commercial and beneficial to the public. Fair use is the strongest defense is correct. Copyright protection does not automatically expire simply because the work is used. Emergency broadcast. If the public domain argument does not apply, B is incorrect. Sovereign immunity can apply in certain cases, but federal and state agencies can still be subject to copyright infringement claims, particularly under the Copyright Remedies Clarification Act or CA. C is incorrect. The First Amendment does not override copyright law but can be factored in fair use analysis. However, it does not grant automatic access to copyrighted works. D is incorrect. Question 6. While examining inconsistencies across various units of a technology company, legal disputes often arise regarding software patents and trade secrets. Suppose a startup company develops an AI-driven algorithm that improves cybersecurity and patents its technology. Later, a former employee joins a large competitor and develops a similar system. The startup company sues for both patent infringement and misappropriation. Trade secrets under the Defend Trade Secrets Act (DTSA). Which of the following factors will be most critical in determining whether the competitor is liable for both claims? A. Whether the former employee had access to the patented technology while working at the startup. B. Whether the competitor's technology performs the same function as the startup's patented technology. C. Whether the startup took reasonable steps to protect its trade secret before the employee left. D. Whether the competitor's system uses the exact same code as the startup's AI-driven algorithm. Answer C. Whether the startup took reasonable steps to protect its trade secret before the employee left. Explanation. Patent infringement and trade secret misappropriation are distinct legal claims with different legal standards. Patent infringement occurs when a competitor makes, uses, or sells a patented invention without authorization. The functionality and technical aspects of the patented invention are key considerations. Trade misappropriation under the Defend Trade Secrets Act (DTSA) requires that 1. The information was a trade secret, 2. It was misappropriated, and 3. The owner took reasonable measures to protect it. In this case, the most critical factor for the trade secret claim is whether the startup implemented proper confidentiality agreements, access restrictions, and security measures before the employee left. C is correct. If the company did not take steps, the competitor may not be held liable. If the former employee had access to the patented technology, that could be relevant but does not automatically prove infringement. Is incorrect. Patent infringement requires more than just similarity in function. The competitor's product must contain the patented claims. B is incorrect. For trade secret misappropriation, exact copying is not required. Even an authorized use of general knowledge gained from trade secret can be enough, thus requiring the exact same code is too narrow of standard. D is incorrect. Question 7. During a major transformation where existing methods of copyright protection are challenged by new technological advancements, an online publishing platform introduces an AI-based system that autonomously generates written content, musical compositions, and digital artwork. A dispute arises regarding whether the AI or the company that owns the system should hold the copyright to the works. Given established copyright principles, who would likely own the copyright, and why? A. The AI system, because it is the actual creator of the works. B. The company that owns and operates the AI system, because it provided the necessary input and infrastructure. C. The users who prompted the AI system as they influenced the final outcome. D. No one, because copyright law does not recognize non-human creators. Answer D. No one, because copyright law does not recognize non-human creators. Explanation. Under existing copyright law, including the U.S. Copyright Act and international treaties like the Berne Convention, copyright is granted only to human authors. Courts and copyright offices such as the U.S. Copyright Office and UK Intellectual Property Office have ruled that AI-generated works cannot be granted copyright protection unless a human demonstrates sufficient creative input. The recent Thaler v. Perlmutter case in the U.S. reaffirmed this principle, stating that AI cannot be listed as an author is incorrect because AI is not recognized as a legal person with intellectual property rights. B is incorrect because ownership generally requires human authorship even if a company owns the AI system. C is incorrect because users may influence AI output, but their contributions often lack the originality required for copyright. This question highlights ongoing legal debate about AI and copyright law, which remains an unresolved area requiring legislative clarification. Question 8. In a case where multiple parties have different objectives regarding trademark ownership, a multinational corporation enters into a joint venture with a local business to develop a new product. Both companies agree to use the same trademark but fail to specify ownership rights in their contract. Years later, the local business claims sole ownership of the trademark, arguing that it primarily marketed and distributed the product. Multinational corporation disputes this, stating that it developed the brand identity and registered the trademark internationally. Based on trademark principles, who is most likely to prevail? A. The local business, since it controlled the marketing and distribution. B. The multinational corporation, since it registered the trademark internationally. C. Both companies have joint ownership and must negotiate usage rights. D. The party that can demonstrate priority of use in the relevant market. Answer: D. The party that can demonstrate priority of use in the relevant market. Explanation: trademark rights are primarily based on first use in commerce rather than mere registration, particularly in jurisdictions that follow common law principles, such as the US and UK. Courts often consider factors such as brand recognition, marketing efforts, and customer perception. Is incorrect because marketing alone does not establish ownership if another party used the mark first. B is incorrect because international registration does not automatically override local prior use. C is incorrect because joint ownership is not automatically assumed unless expressly agreed upon. This question underscores the importance of clear contractual agreements in co-branding arrangements and the risks of failing to define trademark ownership. Question 9. While investigating a complicated issue between different jurisdictions regarding patent enforcement, a pharmaceutical company secures a patent in the US for a life-saving drug. However, a generic drug manufacturer in another country begins producing and selling a similar product without a license. Citing the lack of a local patent, the pharmaceutical company seeks to block the sales under international patent law. What is the likely outcome? A. The pharmaceutical company can enforce its U.S. patent worldwide through the TRIPS agreement. B. The generic manufacturer is legally allowed to produce the drug if there is no local patent protection. C. The World Trade Organization earlier and impose sanctions on the generic manufacturer. D. The pharmaceutical company can sue in the International Court of Justice to enforce the patent. Answer: B. The generic manufacturer is legally allowed to produce the drug if there is no local patent protection. Explanation: patents are territorial, meaning that they must be granted in each country where protection is sought. The Agreement on Trade-Related Aspects of Intellectual Property Rights (TRIPS) sets minimum standards but does not provide automatic global enforcement. It is incorrect because the TRIPS agreement does not extend patent beyond national borders. C is incorrect because the WTO does not enforce individual patents or impose sanctions in such cases. D is incorrect because the ICH does not have jurisdiction over private IP disputes. This scenario highlights the importance of international patent filing strategies, such as using the Patent Cooperation Treaty (PCT) to secure rights in multiple countries. Question 10. In a high-stakes environment where multiple challenges exist in digital copyright enforcement, a streaming platform is sued by record labels for allowing users to upload and share copyrighted music without authorization. The platform argues that it operates as an intermediary and is protected under safe harbor provisions. What is the key legal principle governing its liability? A. The platform is liable unless it actively polices all content uploaded by users. B. The platform is protected under the Digital Millennium Copyright Act (DMCA) if it complies with takedown requests. C. The record labels must prove actual damages before the platform can be held liable. D. The platform is automatically liable since it profits from the copyrighted material. Answer: B. The platform is protected under the Digital Millennium Copyright Act (DEA) if it complies with takedown requests. Explanation: under the DSEA 17 U.S.C. SS 512, online service providers can avoid liability if they follow the safe harbor rules, responding to valid takedown notices from copyright holders. Implementing policy to terminate repeat infringers, not directly encouraging infringement, is incorrect because platforms are not required to monitor all user content proactively. C is incorrect because damages are not required to establish copyright infringement. D is incorrect because liability depends on knowledge and action, not profit. This case reflects landmark rulings such as Viacom v. YouTube 2013 and highlights evolving challenges of digital copyright law. Question 11. When developing a solution that must address opposing needs in trademark disputes, a luxury fashion brand sues a small independent clothing business for using a name similar to its registered trademark. The small business argues that it sells a different type of clothing and operates in a separate geographic market. How would a court likely decide this case? A. The luxury brand will win if it can prove that the small business causes customer confusion. B. The small business will win because it operates in a different geographic market. C. The luxury brand will win automatically because it has a registered trademark. D. The small business will win if it proves that its name was created independently. Answer A. The luxury brand will win if it can prove that the small business causes customer confusion. Explanation. Trademark law is designed to prevent consumer confusion regarding the source of goods or services. Courts use the likelihood of confusion test, considering factors such as similarity of the marks in appearance, sound, or meaning, relatedness of the goods services, strength of the senior user's mark. Famous brands get broader protection. Actual confusion among consumers. B is incorrect because geographic market separation is less relevant in the Internet era. C is incorrect because registration alone does not grant absolute protection. D is incorrect because independent creation does not negate likelihood of confusion. This case highlights the balance between protecting brand identity and fair competition. Question 12. While managing a hybrid approach where timing issues affect patent filing strategies, a technology startup develops an innovative software algorithm but delays filing for a patent. Months later, a larger competitor files a patent application for a similar technology. The startup now seeks to claim prior inventorship. Under patent law, what is its best course of action? A. File a lawsuit arguing that it was the first to invent. B. Attempt to invalidate the competitor's patent by proving prior public disclosure. C. Immediately file patent application with proof of concept. D. Argue that software cannot be patented under current laws. Answer B. Attempt to invalidate the competitor's patent by proving prior public disclosure. Explanation. In jurisdictions following first to file systems such as the US. After the America Invents Act of 2011, patent rights go to the first party to file, not necessarily the first to invent. However, prior public disclosure, use, or publication before the competitor's filing date can be used to challenge the patent's validity. Is incorrect because the US no longer follows first to invent system. C is incorrect because filing late does not override an earlier patent application. D is incorrect because software can be patented if it meets eligibility criteria. This question highlights the importance of timely patent filings and strategic disclosure management. Question 13. In an environment where different components must interact in a trade secret protection strategy, a company discovers that an ex-employee shared its confidential formula with a competitor. The company never registered a patent but had strict internal policies on confidentiality. How can it protect its intellectual property? A. Sue for trade secret misappropriation under the Defend Trade Secrets Act, DTSE. B. Register the formula as a patent and then sue for infringement. C. Demand the competitor return the information and cease use without legal action. D. File a copyright claim as the formula is an original work. Answer A. Sue for trade secret misappropriation under the Defend Trade Secrets Act, DTSE. Explanation. Trade secrets are protected without registration if reasonable efforts were made to maintain secrecy, e.g., NDAS, restricted access. Under the DTSE 2016, a company can take legal action against theft or misappropriation. B is incorrect because patents must be filed before public use and trade secrets lose protection if patented. C is incorrect because voluntary return does not guarantee future misuse. D is incorrect because copyright does not protect functional information like formulas. This question illustrates the differences between trade secrets and patent and IP strategy. Question 14. When scaling up operations that experience significant trademark dilution risks, a well-known sports where a company notices that numerous small businesses are using similar logos for their products. Some businesses are not direct competitors but benefit from the brand's reputation. What legal remedy is most effective? A. File trademark infringement lawsuits against all businesses. B. Pursue trademark dilution claim even without customer confusion. C. Ignore the issue as the small businesses do not compete directly. D. Negotiate licensing agreements with the small businesses. Answer: B. Pursue a trademark dilution claim even without customer confusion. Explanation: under U.S. trademark law, Lanham Act 15 U.S.C. SS 1125 C. Famous brands can file dilution claims arguing that unauthorized use blurs distinctiveness, brand overuse reduces uniqueness, tarnishes reputation, association with inferior goods, is incorrect because infringement requires likelihood of confusion. C is incorrect because ignoring dilution can weaken brand's exclusivity. D is incorrect because licensing unauthorized users could set precedent. This case shows the importance of proactive brand protection. Question 15. While examining inconsistencies across various units in a copyright fair use analysis, a documentary filmmaker uses short clips from a popular movie without permission. The studio demands takedown, but the filmmaker argues fair use. What factors determine if fair use applies? A. The filmmaker's purpose, the nature of the work, the amount used, and the market impact. B. The film's popularity and the filmmaker's intent to educate. C. The percentage of total runtime used, regardless of context. D. Whether the studio has ever allowed others to use clips before. Answer: A. The filmmaker's purpose, the nature of the work, the amount used, and the market impact. Explanation: under 17 U.S.C. SS 107, fair use considers purpose educational versus commercial, nature factual versus creative work, amount small necessary excerpts versus substantial copying, market harm whether the use replaces demand for the original. B is incorrect because intent alone does not determine fair use. C is incorrect because percentage is not sole factor. D is incorrect because past permissions do not dictate fair use. This quest highlights fair use as nuanced defense, not guaranteed right. Question 16. During a major transformation where existing methods of copyright enforcement are being reevaluated, a music streaming platform begins using AI-generated playlists that include songs without explicit licenses. Some artists claim copyright infringement, while the platform argues that its AI merely organizes publicly available music. What legal principles determine liability in this case? AI-generated playlists do not require licenses because they are compilations, not reproductions. B. The platform may be liable if it directly streams copyrighted songs without proper licensing. C. The platform is not responsible because users, not the platform, initiate playback. D. As long as the platform does not claim ownership of the music, there is no infringement. Answer: B. The platform may be liable if it directly streams copyrighted songs without proper licensing. Explanation: copyright law protects reproduction, distribution, and public performance of musical works. Streaming platforms must obtain licenses, mechanical or performance, before making copyrighted music available. Even if AI-generated playlists curate songs, the platform could still be liable if it streams the content without securing proper rights. It is incorrect because AI-generated compilations do not override copyright laws. C is incorrect because platforms that provide direct access may still be secondarily liable. See Napster case. D is incorrect because ownership claims are irrelevant. If streaming unlicensed music is an infringement. Scenario highlights the evolving challenges of copyright in the AI era and the necessity of digital licensing agreements. Question 17. In a scenario where efficiency decreases across multiple jurisdictions due to conflicting intellectual property laws, a multinational corporation faces issues enforcing its patent portfolio across different countries. Some jurisdictions recognize software patents, while others do not. How should the company best manage this challenge? A. Seek international patents under the Patent Cooperation Treaty (PCT) to streamline enforcement. B. Accept that patent rights are local and enforce them only where they were granted. C. Use trade secrets instead of patents to avoid jurisdictional conflicts. D. Register copyrights instead, since copyright protection is globally harmonized. Answer: A. Seek international patents under the Patent Cooperation Treaty (PCT) to streamline enforcement. Explanation: patent rights are territorial, meaning a U.S. patent does not grant protection in Europe or Asia. The PCT allows applicants to file one international application, deferring country-specific filings while preserving priority. B is incorrect because global businesses benefit from strategic multi-jurisdictional filings. C is incorrect because trade secrets do not provide enforceable exclusive rights. D is incorrect because copyright and patents protect different aspects of innovation. Highlights the strategic role of international patent filings in global business operations. Question 18. While investigating a complicated issue between different software companies disputing API usage, a startup uses another company's API to build competing products. The larger company claims copyright infringement, while the startup argues that these are functional and not copyrightable. What precedent is most relevant in resolving this dispute? A. Oracle v. Google 2021, which ruled that API use may qualify as fair use. B. Sony v. Universal 1984, which established personal use as fair use defense. C. Feist v. Rural 1991, which ruled that factual compilations lack copyright protection. D. Campbell v. Cuff-Rose 1994, which addressed transformative fair use in music. Answer A. Oracle v. Google 2021, which ruled that API use may qualify as fair use. Explanation. The Oracle v. Google case determined that Google's use of Java constituted fair use because the API was used to create new functionality. The copying was transformative, not mere duplication. The purpose was interoperability, not market substitution. B is incorrect because Sony v. Universal was a personal recording, not software. C is incorrect because Feist dealt with database facts, not APIs. D is incorrect because Campbell focused on music, not software. This question underscores the complexity of software copyright law and fair use considerations. Question 19. During the introduction of new methods where coordination between patent offices is necessary, an entrepreneur files a U.S. patent application but later wants protection in Europe and China. What must be considered when expanding patent protection internationally? A. The Paris Convention allows applicants to claim priority if filed within 12 months. B. A U.S. patent automatically grants protection in allied countries. C. The Berne Convention ensures patents are recognized internationally. D. The World Trade Organization enforces global patent rights. Answer A. The Paris Convention allows applicants to claim priority if filed within 12 months. Explanation. The Paris Convention 1883 enables patent applicants to file in member countries within 12 months of their first filing date while preserving priority. B is incorrect because patents are territorial. C is incorrect because the Berne Convention applies to copyright, not patents. D is incorrect because the W enforces agreements, not patent applications. This highlights the importance of global patent strategies and filing deadlines. Question 20. In a multi-location scenario where consistency requirements in trade dress protection arise, a chain restaurant wants to prevent copycat businesses from mimicking its store layout and branding. What legal doctrine applies? A. Trade dress protection, which covers non-functional design elements. B. Copyright law, which protects interior designs automatically. C. Patent law, which grants exclusive rights to store concepts. D. Contract law, which requires customers to sign agreements not to copy designs. Answer A. Trade dress protection, which covers non-functional design elements. Explanation. Trade dress, protected under Lanham Act SSA, refers to the look and feel of brand, such as store layout, color schemes, packaging design. B is incorrect because copyright law does not cover functional or useful design elements. C is incorrect because patents protect inventions, not brand aesthetics. D is incorrect because customers are not bound by contract regarding store design. This question emphasizes the role of trade dress in brand identity and unfair competition. Question 21. While updating traditional approaches where interconnections between licensing and fair use are debated, a video game streamer broadcasts gameplay with background music owned by a record label. The label issues a copyright takedown. Does the streamer have a fair use argument? A. No, because streaming includes commercial elements. B. Yes, if the music is incidental and not the main focus. C. No, because fair use does not apply to digital streaming. D. Yes, because all background music in games is fair use. Answer B. Yes, if the music is incidental and not the main focus. Explanation. Fair use is determined by context. If background music is incidental and not the focus, some courts may consider it transformative. However, if music plays a prominent role, a claim of fair use weakens. Is incorrect because commercial use does not automatically negate fair use. C is incorrect because fair use can apply to digital media. D is incorrect because not all background music is fair use. This highlights the evolving legal landscape of streaming and copyright enforcement. Question 22. During an emergency response where multiple areas are impacted by cybersecurity threats, a large corporation experiences a ransomware attack that locks its critical systems. Some employees suggest paying the ransom to regain access, while others advocate for restoring backups and reporting the incident to authorities. What is the best course of action based on cybersecurity best practices? A. Pay the ransom immediately to regain access as quickly as possible. B. Disconnect affected systems, restore backups, and report the attack. C. Negotiate with the attackers for a reduced ransom amount. D. Ignore the attack and wait for the ransomware to expire. Answer. B. Disconnect affected systems, restore backups, and report the attack. Explanation. Cybersecurity best practices strongly discourage paying ransoms because there is no guarantee that attackers will restore access. Paying encourages further attacks. The funds may support criminal organizations. The best approach is isolate affected systems to prevent further spread, restore from backups if available, report the incident to law enforcement, e.g. FBI at CISA is incorrect because paying is not a guaranteed solution. C is incorrect because negotiating still funds cyber criminals. D is incorrect because ransomware does not expire, it requires action. This question highlights cyber incident response strategies in a high-risk environment. Question 23. When developing a solution that must address opposing needs in software development, a company is torn between prioritizing security and user experience. Developers argue that stronger authentication slows down users while security teams insist on stricter measures. How should the company balance these concerns? A. Implement the highest security standards even if it inconveniences users. B. Use a risk-based approach, implementing multi-factor authentication (MFA) when necessary. C. Prioritize ease of use over security to retain more customers. D. Remove security features if users complain about difficulty. Answer. B. Use a risk-based approach, implementing MFA where necessary. Explanation. The best solution balances security and usability by assessing risk levels, e.g., stricter security for financial transactions, implementing MFA selectively, e.g., requiring it for high-risk actions but not for every login, using adaptive security such as behavioral analysis for authentication is incorrect because excessive security can lead to poor user adoption. C is incorrect because security vulnerabilities can cause greater harm. G. Data breaches. D is incorrect because removing security measures exposes the company to attacks. This quest illustrates the trade-offs in security and user experience design. Question 24. While analyzing the root causes of sequential problems in supply chain management, a retail company experiences repeated delays due to unpredictable supplier shortages. How can the company improve supply chain resilience? A. Use multi-sourcing strategies instead of relying on a single supplier. B. Reduce inventory to minimize storage costs. C. Maintain a just-in-time JIT model to increase efficiency. D. Ignore supplier issues and focus on marketing. Answer A. Use multi-sourcing strategies instead of relying on a single supplier. Explanation. A resilient supply chain requires supplier diversification to reduce risk. Multi-sourcing means the company is not dependent on a single supplier. Delays from one supplier can be mitigated by others. Risk is spread across different geographic locations. B is incorrect because reducing inventory without backup plans increases risk. C is incorrect because JIT increases vulnerability to disruptions. D is incorrect because marketing does not solve supply chain problems. This question highlights risk mitigation strategies in supply chain management. Question 25. In a situation where formal requirements conflict with practical implementation in project management, a construction project faces regulatory delays due to strict zoning laws. The project team argues that the rules do not align with real-world conditions. What is the best approach? A. Follow all formal requirements even if they seem impractical. B. Seek regulatory exemptions or modifications based on project needs. C. Ignore zoning laws and proceed with construction. D. Delay the project indefinitely until regulations change. Answer. B. Seek regulatory exemptions or modifications based on project needs. Explanation. Regulatory frameworks exist to ensure safety and compliance, but they also allow for modifications under certain conditions. Variance requests allow deviations if justified. Stakeholder engagement can lead to alternative solutions. Legal channels exist to challenge impractical regulations. It is incorrect because strict compliance with flexibility may hinder projects. C is incorrect because violating zoning laws can result in fines or legal action. D is incorrect because indefinite delays are not a solution. This question highlights navigating regulatory challenges in project management. Question 26. During a seamless transition where continuity must be maintained in infrastructure, a company migrates its data center to a cloud-based solution. What is the most important consideration? A. Ensuring data integrity and minimal downtime during the migration. B. Migrating all systems at once for a faster transition. C. Relying only on cloud providers for security. D. Ignoring legacy system compatibility. Answer A. Ensuring data integrity and minimal downtime during the migration. Explanation. A successful cloud migration requires data integrity checks to prevent corruption or loss, minimal downtime to avoid business disruption, hybrid migration strategies such as phased rollouts. B is incorrect because gradual migration is safer than moving everything at once. C is incorrect because companies must manage their own security. D is incorrect. Legacy systems may need adaptations. This question emphasizes best practices in cloud migration strategies. Question 27. When scaling up operations that experience significant workforce resistance, a manufacturing company implements automation, leading to employee pushback. What is the best approach to address concerns? A. Involve employees in change management discussions. B. Automate immediately without discussing with employees. C. Offer severance packages to employees who resist. D. Ignore resistance and continue as planned. Answer A. Involve employees in change management discussions. Explanation. Effective change management includes transparency about automation plans, reskilling programs for employees, gradual implementation with feedback loops. B is incorrect because sudden changes can lower morale. C is incorrect because severance does not address long-term concerns. D is incorrect because ignoring resistance can lead to poor adoption. This question highlights the factors in automation adoption. Question 28. While investigating inconsistencies across various units in financial reporting, a company finds discrepancies in revenue recognition policies across different regions. What should it do? A. Standardize revenue recognition policies across all units. B. Allow regional variations to continue. C. Ignore minor inconsistencies. D. Adjust financial reports manually each quarter. Answer A. Standardize revenue recognition policies across all units. Explanation. Consistent financial reporting ensures compliance with international standards, GOP-IFUs, improves investor confidence by reducing irregularities, reduces audit risks and legal exposure. This question highlights best practices in corporate financial consistency. Question 29. In an environment where different components must interact efficiently in system design, software engineers must integrate legacy systems with new cloud platforms. What is the best approach? A. Use APIs and middleware for seamless integration. B. Replace all legacy systems immediately. C. Keep legacy systems completely separate. D. Avoid upgrading to newer technologies. Answer A. Use APIs and middleware for seamless integration. Explanation. Middleware solutions allow legacy and modern systems to communicate without requiring full replacement. This question highlights practical solutions for modernization. Question 30. When addressing systemic weaknesses that lead to recurring failures in organizational risk management, a financial institution discovers that its fraud detection system has repeatedly failed to identify sophisticated scams. What is the most effective long-term solution? A. Implement artificial intelligence, AI, and machine learning (ML) to enhance fraud detection capabilities. B. Continue using the current system but increase manual reviews. C. Reduce fraud monitoring to lower operational costs. D. Ignore past failures and assume they will not happen again. Answer A. Implement artificial intelligence, AI, and machine learning (ML) to enhance fraud detection capabilities. Explanation. Sophisticated financial fraud tactics evolve constantly, making traditional detection methods insufficient. AI and ML analyze patterns in real time and detect anomalies that humans or rule-based systems might miss, reduce false positives, improving accuracy, adapt dynamically as fraudsters change tactics. B is incorrect because manual reviews alone cannot scale with high transaction volumes. C is incorrect because reducing fraud monitoring increases financial risk. D is incorrect because ignoring systemic weaknesses leads to repeated losses. Question emphasizes the role of AI in risk management and fraud prevention.